Hello, my name is Andrew Kingsdale, and I'm an associate attorney with the law offices of Omar Figueroa. Today, I will discuss some strategies for cannabis businesses to minimize the costs and litigation risks of complying with California's Environmental Quality Act, or CEQA. Omar recently covered Governor Newsom's trailer bill, released on May 10th. This trailer bill would amend California's cannabis statutes in significant ways, such as extending provisional licensing beyond this year. The trailer bill would also extend another key deadline, the cutoff to a cannabis-specific CEQA exemption for cities and counties. Presently, under the Medical and Adult Use Cannabis Regulation and Safety Act, or MALCRSA, until July 1st, 2019, CEQA does not apply to the adoption of an ordinance, rule, or regulation by a local jurisdiction that requires discretionary review and approval of permits, licenses, or other types of authorizations to engage in commercial cannabis activities. And that's Business and Professions Code 26055, Subdivision H. The governor's trailer bill would extend this exemption until July 1st, 2021. This CEQA exemption for cities and counties encourages California's localities to enact commercial cannabis permitting ordinances. But with only about 1/3 of these jurisdictions presently allowing any commercial cannabis business, and tax revenues falling short of goals, it appears that further encouragement is needed. Hence, the trailer bill and this proposed 2-year extension. Nevertheless, while this CEQA exemption may reduce barriers for local governments, it does not offer much relief to cannabis businesses themselves. Indeed, by its own terms, for local governments to be exempt, their individual permitting decisions must require discretionary review. A locality's discretion to issue or deny cannabis permits is part of what brings its permit approval process under CEQA's purview. In other words, if you are applying for a commercial cannabis permit, you still need to make sure your business plans meet CEQA's requirements. The following are some ideas for clearing the CEQA hurdle with the goal of minimizing potential costs and delays. First, understand your local jurisdiction's CEQA approach. As lead agencies for CEQA purposes, cities and counties assume primary responsibility for approving or denying individual permit applications based on CEQA's requirements. Therefore, each business should work closely with its local jurisdiction to understand its assessment of which impacts are deemed significant and may need to be mitigated. California's cities and counties have reached widely different conclusions about the likelihood and severity of commercial cannabis environmental impacts. Some have bypassed any analysis, taking advantage of MALCRSA's CEQA exemption, as previously discussed. Others have conducted in-depth EIRs, or environmental impact reviews. Permit applicants should understand where their jurisdiction falls on this spectrum and which impacts, if any, are important to their jurisdiction. This information is especially crucial for project management purposes because expert studies about certain CEQA impact factors can take much longer than others to schedule and to complete. Additionally, an applicant may be able to teeter off of its local jurisdiction's prior analyses, especially if the jurisdiction already has completed an EIR reaching conclusions about particular environmental impacts that are related to the applicant's project. So start local and get focused on key impact factors early on. Second, we recommend cannabis businesses try to tailor their permit applications to fit within a project-level CEQA exemption, or fit into multiple exemptions if that's an option. CEQA has a number of exemptions, most commonly statutory exemptions and categorical exemptions. If a project meets an exemption, then it generally will not require expensive analysis of environmental impacts because it's predetermined not to have significant impacts on the environment. The Bureau of Cannabis Control encourages this approach. Its CEQA exemption petition form suggests certain exemptions that may commonly apply to cannabis businesses. These common exemption categories have two general themes. First, projects with pre-existing facilities or pre-developed land, and the other is projects that are minor alterations to land. CEQA heavily favors project applicants who build on already constructed or already disturbed land. When a cannabis permit applicant is choosing a potential site for its facility, it should keep these exemptions in mind, along with other land use and zoning requirements, of course. CEQA exemptions are helpful but not foolproof, however, because they are not absolute and claims of exemption may be subject to challenge, which leads to the next tip. Know and work with your community. NIMBY and anti-cannabis neighbors can weaponize CEQA to delay or kill a cannabis project, which is why community outreach is critically important. Inform and educate your neighbors early on to make them feel heard. Get their buy-in before breaking ground. Is your community concerned about traffic, odors, noise, pesticides? Try to find a common ground solution or mitigate potential impacts in CEQA speak to avoid time-consuming and costly battles. If a permit application fits within one or more categorical exemptions, exceptions to these exemptions can apply to require a deeper study of environmental impacts. For example, long-term cumulative impacts of a cannabis operation might be significant enough to merit further study. So too with particularly sensitive environmental surroundings or important historical or archaeological areas. So don't just rely on CEQA exemptions, also rely on good community relations, which must be cultivated and carefully tended to from the inception of the project. Finally, we recommend cannabis businesses talk to a CEQA environmental consultant early on. Develop a CEQA strategy early and prepare for hiccups along the way. CEQA environmental consultants can help permit applicants spot potential problem areas, evaluate the significance of potential environmental impacts, recommend ways to mitigate those impacts, and advise on the appropriate environmental documents to prepare. This upfront legwork will build a defensible CEQA compliance approach if disputes ever should arise. Environmental analysis and impact reports can be very expensive, potentially costing a small cultivator around $40,000 to $60,000. But failing to do the studies can cost a lot more than that down the road if the project is held up in litigation. In conclusion, CEQA is complicated, and reasonable minds can differ about how significant a particular environmental impact is. This is yet another area of law where an ounce of prevention can save a ton of headache and heartache in the future. Thank you for listening, and please contact our law offices if you would like additional assistance with your cannabis business.